Have you ever wondered how to participate in an arbitration competition? Fear not, we have the answers right here. Picture yourself in the thrilling world of arbitration, an essential aspect of dispute resolution. It's a place where the sharpness of your mind, the strength of your arguments, and your ability to navigate complex legal issues can shine. Imagine participating in the TMI arbitration competition, a prestigious platform that gives students a chance to deepen their understanding of arbitration. But how does one participate and run a successful arbitration competition? Let's demystify the process. First, you have to form a team. This team should consist of 4 students. Within this team, 2 students will take on the role of lawyers, while the other 2 will portray witnesses in each round. Bear in mind that these roles can switch between rounds, but they must remain consistent within a single round. Arbitration is a contract-based form of binding dispute resolution. It involves several steps, including arbitration agreement, the existence of an agreement. The arbitration agreement between parties determines their right to refer a dispute to arbitration. The agreement specifies that the dispute may be resolved through arbitration. 1. Selection of arbitrator. Parties select an arbitrator or a panel. The arbitrator is a disinterested third party who directs the hearings and renders judgment. 2. Statements and evidence. Parties submit statements and present their evidence during the arbitration process. The arbitrator considers the arguments and evidence presented by both sides. Arbitration hearing. The arbitration hearing takes place where parties present their case. The arbitrator listens to arguments, examines evidence, and asks questions. Arbitrator's decision. After considering all aspects, the arbitrator makes a binding decision. This decision is enforceable and legally binding on the parties involved. 3. Arbitration offers a streamlined alternative to traditional court litigation, providing an efficient way to resolve disputes. It's essential to understand the arbitration process and the role of the arbitrator in ensuring a fair outcome. Next comes the competition format. Your team will need to prepare and present an arbitration case. This isn't just about arguing a case, it's about simulating a realistic arbitration hearing. That includes delivering opening statements, examining witnesses, introducing exhibits, presenting evidence, and giving summations. Arbitration offers several advantages over traditional litigation. Let's explore these benefits. Cost efficiency. Arbitration tends to be less expensive than litigation. It involves fewer procedural hurdles and streamlined processes. Additionally, arbitration can be faster, often resolving disputes more quickly than court cases, which can drag on for years. Confidentiality and privacy. Arbitration proceedings are private and confidential. Unlike court hearings, which are often open to the public, arbitration maintains a level of discretion. Choice of decision maker. Parties in arbitration have the ability to select a fair and qualified decision maker, arbitrator. This personalized choice can lead to more satisfactory outcomes. Tailored process. Flexibility is a key advantage. Parties can customize the arbitration process to suit their specific needs and preferences. Time efficiency. Arbitration typically resolves disputes faster than litigation. Court cases can be time-consuming, whereas arbitration offers a more streamlined timeline. Finality. Arbitration decisions are binding and final. There are limited grounds for appeal, ensuring a conclusive resolution. In summary, while both arbitration and litigation have their place, arbitration's efficiency, privacy, and tailored approach make it an attractive choice for certain disputes. Then get ready for the regional competitions. These competitions are held both in person and virtually. Each team competes in 2 rounds, and the top 4 teams advance to the semi-finals. The first place team from each regional competition then proceeds to the national finals. But what about communication and responsibilities? It's crucial to designate a main contact for your team. This person will receive all communication from the TMI regarding the competition, including regional assignments and the problem. It's their responsibility to share all communication with the rest of the team. Faculty members or team coaches can assist in managing important details. Let's explore the key differences between mediation and arbitration. Mediation. Purpose. Mediation is a collaborative process designed to facilitate communication between parties involved in a dispute. Third-party mediator, a neutral third party, often an attorney, retired judge, or therapist, assists in reaching a resolution. Voluntary and non-binding. Mediation is typically voluntary, but sometimes courts require it before proceeding with a case. Outcome: the mediator does not impose a specific resolution. Instead, they guide discussions to help parties find common ground. Common use. Mediation is commonly used in divorce cases and situations where ongoing relationships, for example business partners, need to be maintained. Benefits: parties are more likely to feel satisfied with the resolution since they actively participate in creating the agreement. Mediation is usually non-binding, allowing flexibility in outcomes. 12. Arbitration. Purpose. Arbitration is a method of resolving disputes where a neutral arbitrator, similar to a judge, makes the final decision. Formal process. Each party presents their case to the arbitrator, who considers evidence and legal arguments. Binding decision. Arbitration decisions are binding and enforceable like court orders. Common use. Arbitration is often used in contractual disputes, labor disputes, and commercial matters. Benefits: it offers a streamlined alternative to court litigation, with faster resolution and privacy. 34. In summary, mediation focuses on communication and collaboration, while arbitration involves presenting evidence to a decision-maker. Both methods have their advantages, and the choice depends on the specific circumstances of the dispute. Finally, take advantage of the recent problems and final round recordings. These resources are available for educational purposes at no cost and can be shared within your school. They can provide invaluable insights into the competition and can help you prepare effectively. In summary, participating in an arbitration competition involves forming a team, understanding the competition format, preparing for the regional competitions, and taking on specific communication responsibilities. It's a journey that requires teamwork, strategic preparation, and a keen understanding of arbitration. So, step into the world of arbitration and make your mark.